Welcome to Chapter 2, Data Fiduciaries' Obligations under the DPDP Act 2023. In this chapter, we'll explore the critical roles and responsibilities of data fiduciaries and data processors. The Digital Personal Data Protection Act 2023, DPP Act, lays out clear obligations for data fiduciaries and data processors to ensure that personal data is handled securely, ethically, and in compliance with the Act. In this chapter, we will examine the roles and responsibilities of data fiduciaries and data processors, focusing on data security, the principle of data minimization, and the obligation to ensure transparency and accountability in data processing activities. Responsibilities of data fiduciaries and data processors. The DPDP Act distinguishes between two key roles in the data processing ecosystem: data fiduciaries and data processors. Both have specific obligations under the law, but their responsibilities differ. 1. Obligations of data fiduciaries, Section 8. New requirement. Significant data fiduciaries must conduct regular data protection impact assessments, or DPIAs, particularly for high-risk processing activities. Example, a large e-commerce platform conducting DPIAs to assess risks like data leakage in personalized marketing. 2. Appointment of data protection officers, Section 10. New requirement. Significant data fiduciaries must appoint a qualified data protection officer to oversee compliance and manage privacy concerns. Example, a multinational tech company appointing a DPO to adhere to Indian and global data protection laws. 3. Data processing audits. New provision. Regular audits must be conducted to maintain records of data processing practices. Example, a healthcare provider auditing annually to ensure health data is used only for patient care. These provisions emphasize accountability, ensuring data privacy remains a priority. Data fiduciaries' responsibilities. A data fiduciary is the entity or individual responsible for determining the purposes and means of processing personal data. These can include businesses, organizations, and government bodies that collect and process personal data for specific purposes. The DPDP Act assigns several critical responsibilities to data fiduciaries. 1. Obtain consent, Section 6. Data fiduciaries must obtain explicit, informed, and unambiguous consent from data principals before collecting or processing their personal data. Example, a telecom company must inform the customer about what personal data will be collected, e.g. location data, usage, and the purpose, e.g. billing, marketing, or service improvement. 2. Ensure data accuracy, Section 12. Data fiduciaries must ensure that the personal data they process is accurate, complete, and up to date. They must take steps to correct, complete, or update the data as required. Example, a bank must ensure that customer details such as addresses or contact numbers are accurate and up to date, particularly when a customer changes their address. 3. Implement data protection measures, Section 8. Adequate technical, organizational, and security measures must be implemented to protect personal data from unauthorized access, data breaches, and loss. Example, an e-commerce platform must encrypt sensitive customer data like credit card details to ensure secure transactions and prevent data breaches. Notify in case of data breach, Section 8.6. Data fiduciaries must notify both the affected data principal and the Data Protection Board immediately in the event of a data breach, detailing the breach's nature, the affected data, and the measures taken to mitigate it. Example, if an online retail company experiences a breach involving customer payment information, it must notify affected customers and the Data Protection Board promptly, outlining the steps it will take to resolve the breach. Data processors' responsibilities. A data processor is an entity or individual that processes personal data on behalf of a data fiduciary. Unlike data fiduciaries, data processors do not determine the purposes of data processing. They simply carry out processing activities under the instructions of the data fiduciary. 1. Process data only on instructions, Section 8.2. Data processors must only process personal data according to the instructions given by the data fiduciary and must not use it for any other purpose. Example, a cloud storage provider stores user data on behalf of an e-commerce platform. The cloud provider can only store the data and cannot use it for its own purposes, such as selling it for advertising. 2. Ensure security of data, Section 8.5. While data fiduciaries bear the primary responsibility for data security, data processors must also implement adequate security measures to safeguard the data they handle. Example: a third-party payment processor that handles payment information for an online store must ensure encryption and proper storage security to prevent data breaches. 3. Cooperate with the Data Fiduciary, Section 8.2. Data processors must cooperate with data fiduciaries to help them comply with the DPDP Act, including fulfilling requests for data principal rights and ensuring that data is securely handled. Example: a marketing agency contracted by an e-commerce company must assist in responding to data principals' access or deletion requests related to the marketing data. Obligations regarding data security. One of the core principles of the DPDP Act is to ensure that personal data is handled securely to prevent unauthorized access, alteration, or loss. Both data fiduciaries and data processors are required to implement robust security measures. Technical and organizational measures. Risk assessment and mitigation, Section 8.4. Data fiduciaries must regularly conduct risk assessments to identify any vulnerabilities in their data processing systems and implement steps to mitigate these risks. Example: a hospital handling sensitive health data must implement strong encryption and multi-factor authentication to safeguard patient records. Data encryption. Sensitive personal data should be encrypted both during transmission and while stored to ensure that the data remains protected even if a breach occurs. Access control. Access to personal data must be restricted to authorized personnel only. Organizations should implement role-based access control to ensure that only individuals who need the data for their duties can access it. Relevant section. Section 10.2(I) of the DPDP Act requires significant data fiduciaries to periodically perform DPIAs. Implementing data minimization and purpose limitation. Two of the fundamental principles in the DPDP Act are data minimization and purpose limitation, which help ensure that personal data is collected, processed, and stored responsibly. Data minimization principle. Data minimization ensures that only the personal data necessary for achieving a specific purpose is collected. Example: a job application form should only request relevant details like contact information and work experience, and should avoid asking for irrelevant information, such as the applicant's religious beliefs. Purpose limitation principle. Data collected for one purpose must not be used for another unrelated or unjustified purpose. The data must be processed only for specific, legitimate reasons as disclosed to the data principal. Example: if a user provides their personal data to a social media platform to create an account, the platform must only use that data for providing services and cannot sell it to third parties for marketing purposes without obtaining the user's explicit consent. Relevant sections. Section 4 establishes the conditions under which personal data can be processed. Section 6 requires consent from data principals and emphasizes purpose limitation during data collection. Conclusion and key takeaways. The DPDP Act clearly defines the responsibilities of both data fiduciaries and data processors to ensure that personal data is handled securely, lawfully, and with respect to individuals' rights. The following are the key takeaways from this chapter. 1. Responsibility for compliance. Data fiduciaries are accountable for the lawful processing of personal data, and data processors must follow instructions and maintain data security. 2. Data security measures. Both parties are required to implement adequate security measures to protect personal data from breaches and unauthorized access. 3. Data minimization and purpose limitation. Personal data must be collected only for the specified purpose and should be limited to what is necessary for that purpose. In the next chapters, we will dive deeper into the rights of data principals and the mechanisms for redressal under the DPDP Act, providing a complete view of how the law is enforced and applied in practice. Thank you for joining this session. In the next lesson, we will explore the consent management, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/@prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.